Another hearing today in the Karen Reed case, perhaps the last hearing before trial gets underway, which is scheduled to begin April 1st with jury selection. Over 200 jurors were summoned to the courthouse to see if they will be fit to sit as a juror on this case. So that's going to start April 1st, but it's probably going to be a couple of weeks before they actually get a jury and they go to opening statements. So what happened today in the hearing? Well, before we get into what happened in terms of the argument, Judge Cannoni did let everybody know that her opinion and order regarding defense motion to dismiss is coming out today. Now, I haven't seen that order and opinion yet. As soon as I do, I will go through it, and I'm going to have to devote a different video going through her analysis. But one thing that is clear is that she is denying the motion to dismiss. There's no question about that. The question is only going to be what her analysis is and, of course, whether I agree with her analysis. So we have to wait for her opinion to come out. I haven't seen it yet, and when it does, don't worry, I will give you my analysis on that. So what happened today in court? Well, there's a couple of motions that were argued. There's two main motions. One of them was the motion by the Commonwealth to preclude the defense from arguing a third-party culprit defense. We already went through the motions on this, but we're going to talk a little bit more about it, and especially as it has to do with the law that Hank Brennan argued why the defense should not be allowed to present a third-party culprit defense. Then there was also the motion that Hank Brennan filed to be able to obtain and discover the text messages between David Yannetti and Karen Reed. That's right, David Yannetti, her attorney, and Karen Reed. He argued that Karen Reed waived the privilege since she was talking to Gretchen Voss and on this HBO Max docuseries, and therefore some of the statements that she told over to the public that David Yannetti and her spoke about should be discoverable. This was an interesting issue. However, Judge Cannoni did not want to go there, and she even stopped Robert Alessi in the middle of his argument and said, I'm not going to grant this. So that is already put to bed. So now let's talk about the third-party culprit defense. Now, we did spend a little bit of time going through the law and talking about third-party culprit defense, but what I want to focus on today is the specific cases that Hank Brennan argued in which he believes supports his position that the defense should not be able to argue a third-party culprit defense. So let's also make one thing clear, is that not only is Hank Brennan asking that they should not be able to present some of the evidence about Brian Higgins and Brian Albert and Colin Albert as a evidence of a third-party culprit, but also that they should not be even allowed to present that evidence as a Bowden defense. Remember, there's two different things here. The third-party culprit defense is simply saying that somebody else committed this crime. The Bowden defense is that the police investigation was wholly inadequate. So they're different standards and they're different arguments. And of course, Hank Brennan is arguing that they should not be able to present this evidence at all, not even for a Bowden defense. Bowden defense is a lot easier to argue, but he's arguing that they should not be able to present any evidence about this, whether it has to do with third-party culprit or whether it has to do with Bowden. So let's pull up some of the cases he spoke about. The cases specifically that he argued was Commonwealth versus Moore, Commonwealth versus Stedman, and Commonwealth versus Buckman. Now, of course, I'm not going to be reading for you the entire case. All these cases are pretty interesting. Some of them are pretty gory if you want to read the entire case, but we're just going to be focusing in on specifically what these cases say about their factual scenario as it relates to the third-party culprit. So let's start with Commonwealth versus Moore. Okay, so Commonwealth versus Moore, this is the case right here. And this is what the defense, this is a pretty easy case for the defense to win, to argue. You know, if this is the case that Hank Brennan's relying on, it's not going to be so helpful for him. So this is what happens over here. At trial, what happened? The defendant sought admission of an audio recording of the police radio broadcast published after the shooting that contained various witness descriptions of the suspects. Okay, so in this case, I'm not going to go through the entire factual background, but in this case, essentially what happened is there was some people that broke into someone's house and murdered that person in that house and ran away. Now, there was different accounts, exactly the description of these individuals who broke into the house. So the only argument in this case, as it relates to third-party culprit, was that on the audio, when the police were broadcasting what the description of these shooters look like, well, there was a little bit of a difference in the description. So take a look at footnote 6. You know how much I love footnotes. Take a look at footnote 6. There it says, different portions of the police radio broadcast describe the perpetrators as 5 feet 5 inches tall, 5 feet 6 inches tall, 5 feet 7 inches tall, and 6 feet tall. That's the only argument for third-party culprit, meaning the only argument that the defense was trying to make here is that perhaps it was somebody else just because of the description that the police were broadcasting that maybe did not fit exactly the description of the defendants in this case. They weren't able to identify anybody specifically or any array of people. It was just that this description that the police were using from a few different eyewitnesses, and some were varying in their descriptions. That's what they wanted admitted. You can obviously understand the difference in the Karen Reed case. So this is where the judge felt that this was not a strong enough evidence, and there is no reason why they should reverse because this evidence was not allowed in. The judge did not allow that specific broadcast in. Okay, so to argue that there's a similarity between this case and the Karen Reed case, because in this case, in Commonwealth versus Moore, the judge properly excluded that audio broadcast as any sort of evidence that there's a third-party culprit here. That is not really so similar to what's going on in the Karen Reed case. So that case is not as helpful to Hank Brennan. Nevertheless, he quoted it and he argued it. So I thought, just for the sake of completeness, I'll include it in the analysis. But if you go through this case, you'll see that there's really no other third-party culprits that they can really identify. It was just this perhaps mistaken identification, how tall one of the perpetrators were. That's really what it came down to. Okay, so let's move on to the Commonwealth versus Stedman case. Commonwealth versus Stedman case is also a very troubling case. There's some very gory details here, but we're not going to get into it. But we're just going to talk about really as it relates to the third-party culprit here. So at the time of his death, obviously we're talking about the victim here, Pratt resided in a tent at a campsite in Weymouth. He shared the campsite with a married couple, Kristen Fuller and Robert Fuller, who occupied their nearby tent. Okay, so we have a few people here. Pratt, we have this married couple, Kristen Fuller and Robert Fuller. And then that's who they shared this campsite with. On the morning of July 18th, 2009, Pratt got into an argument with Derek Royal, a frequent visitor to the campsite, about Royal allegedly cutting down Pratt's marijuana plants. Royal left angry. Okay, so you've got this individual, Derek Royal, who got into a fight with this fellow named Pratt, and Royal left angry. Now, the rest of the gory details are here next. Okay, but we're not going to get into it. It's pretty gory. If you want to go ahead and read it, and if you enjoy this stuff, go ahead. But the point is that we're talking about whether Derek Royal in this case is a third-party culprit. So he was a visitor to this campsite, a frequent visitor, and Royal did get into some sort of argument with Pratt regarding cutting down Pratt's marijuana plants. Okay, so coming down back to the argument that some evidence of this Derek Royal should have been admitted and was not, and this is the argument of third-party culprits. We got to get back to the bottom of this case to where the courts are analyzing this specific issue. Here we go. Here, of course, now listen what happened in this case. Here, of course, the defendant was not precluded from introducing all third-party culprit evidence, just evidence of Royal's prior convictions and their factual underpinnings. So what the defense wanted to present was this guy Derek Royal's prior convictions and what the prior convictions' factual underpinnings were. Indeed, the judge permitted the jurors to hear evidence that on the morning before Pratt's murder, Pratt had accused Royal of cutting Pratt's marijuana plants without permission, which led to a lot of argument and Royal angrily leaving the campsite. So the judge did allow that evidence in. The judge also allowed examination of a police investigator regarding the investigation of Royal as a possible suspect. So that was also allowed in. Continuing, going down, the defendant also sought to introduce through copies of the convictions and a police report that Royal had been convicted of 3 additional offenses stemming from a single 1997 encounter: armed robbery, assault and battery by means of a dangerous weapon. The police report contained the recounting by the victim, a homeless man, of how Royal and another tied him up in a wooded area in Quincy, beat him with a tree branch, and robbed him. So that's one of the convictions that this guy Derek Royal was convicted of. He tied somebody up in a wooden area, a homeless man, and he beat him with a tree branch and robbed him. He's robbing a homeless man. All right. Anyway, we conclude that the defendant has not established that Royal's crimes bore substantial connecting links to the murder of Pratt. So, were there any substantial connecting links between these offenses that Derek Royal was convicted of? Does that have anything to do with what happened in this case? No, it had nothing to do with what happened in this case. Most significantly, the attacks occurred 12 and 18 years before Pratt's death. We're talking about 12 to 18 years before. The defendant must show third-party act is closely connected in point of time and method of operation to crime of which defendant is accused. Furthermore, third-party culprit information is admissible under a Bowden defense only if the police had learned of it during the investigation and failed reasonably to act on the information. So then now they're talking about the third-party culprit information as it relates to Bowden. So as long as the police had learned of the third-party culprit information, so then and they failed to reasonably act on it, then that information could be used as a Bowden defense. So as it relates to Bowden, like we said, Bowden is much more wide open than third-party culprit. So Brennan's argument about not being able to admit this third-party culprit evidence of Brian Higgins and Brian Albert and Colin Albert as a Bowden defense, as soon as the police investigators learned about anything that has to do with those phone calls or text messages between Brian Higgins and Brian Albert and Colin Albert, as soon as they learned about it and didn't take any action, right away, you're going to have a Bowden defense. So his argument for Bowden is really not going to go anywhere. It's definitely not going to go anywhere. The question really is about the third-party culprit. So in this specific case, he's using this as support for his argument. I don't think there's anything more I wanted to show you here, but he's using this as support why the third-party culprit information in this case, in Karen Reed's case, should not be admitted. Now, the only connection that you can argue from this case, Commonwealth versus Stedman, and the Karen Reed case is that in Commonwealth versus Stedman, the only piece of information that was not allowed in was something that happened 12 to 18 years ago. It was convictions on an unrelated manner for on this guy, Derek Royal. And that's the only thing that the judge did not allow in. So to argue somehow, how are you going to argue that is similar to the evidence that they have in the Karen Reed case? It's just, is there anything that happened 12 to 18 years before John O'Keefe's death that you can connect and that the defense is trying to connect here? No, they're talking about actions that were taken right then and there, right within very close proximity and time. So again, Commonwealth versus Stedman is not going to be helpful for the Commonwealth in this argument. Now let's move on to Commonwealth versus Buckman. Commonwealth versus Buckman is another case that he relied on. I just want to make sure I didn't miss anything in the top of this. I don't think I did. Okay, so let's go back down. So this is what we said here in Commonwealth versus Buckman. The defendant made an offer of proof regarding at least 3 potential third-party culprits. Okay, so now we're getting a little bit closer. Now we actually have 3 potential third-party culprits. So in the first case, Commonwealth versus Moore, there was none. Commonwealth versus Stedman, there was this Derek Royal guy, and the only piece of evidence was prior convictions of 12 to 18 years before the murder. So now let's see if we can get a little bit closer with this case. So this case is definitely going to be a little bit more helpful for Brennan, but we're going to see whether it actually connects and is an argument that you can make in the Karen Reed case. So the defendant made an offer of proof regarding at least 3 potential third-party culprits. Number 1, a serial killer released from prison in Georgia approximately 2 weeks before the murder in this case occurred. Okay, so that's the first third-party culprit, a serial killer that was released from Georgia. Okay, this is Massachusetts. All right. So who knows? Maybe the serial killer is at it again and he decided to take his act to Massachusetts. Okay. Any sort of connection there? We're going to see. Next. Who's the second third-party culprit? A neighbor of the Buckmans who had shot John Loader's dog while the dog was tied up in the Buckman's front yard. So Loader was the one who discovered the body. Discovered Buckman. He was the one that reported it to the police. Okay. So you got John Loader. And Buckman is the one who's being charged here as the defendant. So a neighbor of Buckman's who had shot John Loader's dog while the dog was tied up in the Buckman's front yard, sparking a lawsuit with John Loader. And so that's the second third-party culprit in this case. and Loader himself, also John Loader himself, who had made the initial report to police and who, after the police failed to locate the victim in their initial search, advised them that the defendant's wife was likely to be in the master bedroom. The defendant's wife, in this case, tragically, was the victim. And again, this is a very gory case. If you want to take a look at the entire case, Commonwealth versus Buckman, go ahead, but it's pretty gory. Anyway, so the wife was murdered. Buckman's wife was murdered. And perhaps John Loader was the one who murdered her. Now, already we're seeing some more connection with this guy, John Loader, and the wife, Buckman's wife. After all, number one, John Loader was the one who initially reported this to the police. And when the police didn't find the body, he was the one who told them that perhaps she is in the master bedroom. Now, Loader is not the defendant in this case, but they're arguing that the defense is arguing that John Loader is a third-party culprit here. All right, let's go down. So they're going to take each one of the possible third-party culprits one at a time. The evidence that the defendant offered regarding the serial killer was not so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Moreover, the defendant cannot place a serial killer in the vicinity at the time of this murder, right? All he knew is that this was a serial killer who got out of jail in Georgia. He couldn't place him in Massachusetts. Admitting evidence that there was a serial killer on the loose would have amounted to mere indirection and would have no relevance in this case. Okay, so that's very simple. Just to say that there's a serial killer on the loose, you can't automatically inject that as a third-party culprit into every single defense case in the country, right? Okay, very, very simple there. Next. Similarly, the fact of tensions between the neighbor, the Buckmans, and John Loader was not indicative of the neighbor's motive to kill, just because they had some sort of disagreement, which resulted in a lawsuit. And the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to kill beyond that possessed by any neighbor. So, yes, he was a neighbor, and therefore he potentially could have the opportunity because he's close he's close, just physically close to the person, but just like any neighbor is close. So is every single neighbor on the block automatically going to be considered a third-party culprit? Of course not. Accordingly, evidence intended to show that the neighbor was a third-party culprit would have been inadmissible. Okay, so those two are pretty easily to move on from. Finally, now this is where we get to the interesting part, John Loader. Finally, defense counsel opposed the Commonwealth's motion in limine based on the following evidence she expected to introduce regarding Loader. Number one, he had a key to the defendant's house. Ooh, okay, interesting. There's a connection. Number two, he found the defendant but did not remove the duct tape. Right? He was the one that found the defendant, and the defendant was duct taped himself. Whether who actually put the duct tape on, you can go ahead and read this case. He may have done it himself. But John Loader found him and didn't remove the duct tape. Number three, he did not telephone a neighbor for help, but instead drove to the police station. Okay, whatever argument, if you buy that argument. What would you do if you found someone taped up with duct tape? Would you call a neighbor for help, or maybe would you go to the police station, or maybe call the police? All right, well, he went to the police station. So part of the argument here is that, well, he must be a third-party culprit because why wouldn't he just call a neighbor? All right, anyway, continuing. 4, he worked for the defendant, knew of the defendant's football card gambling business, and knew there could be money in the house that day. Okay, number 5, Susan Buckman, the victim, was afraid of Loader, having at one point found him on his hands and knees in the upstairs hall. And 6, when he returned to the house, he told police officers that Susan Buckman should be in the bedroom. Defense counsel also pointed out that the Commonwealth had failed to obtain any forensic evidence from Loader. The trial judge correctly noted at the close of the evidence that the defendant failed to offer evidence that tended to show a third person had killed his wife. So you have the husband here, who is the defendant, and the husband is pointing the finger at Loader. Specifically, as to Loader, there was no evidence that he had motive or intent to commit the crime. Third-party culprit evidence is offered for the truth of the matter, and as such, it must have substantial probative value in connecting a third person to the crime. So it's not enough that you can find some connections that he has a key to the house, or that he knew the defendant, he worked for the defendant, he knew about the defendant's football game, card gambling. But what is the motive? What would be his motive or intent to murder his boss's wife? Continuing. The defendant failed to make the requisite showing Evidence that the victim feared Loader because she once discovered him on his hands and knees in the upstairs hall is inadmissible hearsay. It does not tend to show that Loader killed the victim, and the evidence could have confused the jury. So here's a case. Again, you have Loader. Continue one more thing. Although he was not permitted to argue specifically that a third-party culprit committed the crime for which he was charged, he was able to raise the issue through a Bowden defense, which as a practical matter was not so different from a third-party culprit defense here. So again, here you have a situation where the court found that it's not enough to argue third-party culprit, but still you can still argue Bowden defense. So again, the Bowden argument that Hank Brennan is making is very, very, very weak, extremely weak. Of course, they're going to be allowed to present this evidence at the very least as a Bowden defense. But even when it comes to third-party culprit, what connection does Loader have? What type of motive or intent does he have to kill this person's wife, Susan Buckman? Even though he had a key to her house and that he said maybe check the bedroom, this is someone who was around the house. He was always around the house. They were friends. It was his boss's house. He used to hang out together, and he knew about the defendant's football card gambling business. Okay, I mean you know about your boss's businesses that he has. Maybe he was invited to gamble with him. Who knows? So there was really absolutely no evidence here in this case, in Loader's case, where there is some sort of motive or intent for him to commit the crime. What reason would he have at all to murder his boss's wife? Does that make any sense? If you want the money from the gambling business, wouldn't you want to kill maybe the husband, maybe the boss, maybe kill both of them? Instead, you tie up your boss and then kill his wife. Well, what is that? There's just nothing that's making sense to connect Loader to this crime. So these are the three cases that Brennan relied on to make the argument that the third-party culprit defense should not come in. Now, really, we don't have to really spell out why in this case it's very different. This case, when you have Brian Higgins, who is in some sort of flirtatious relationship with Karen Reed, can very easily be understood why he's upset that she's ghosting him and not texting him anymore and not flirting with him anymore, or whatever. That whole relationship is basically done. It's a little fling maybe, but then that's done. So, I mean, there's some connections there. You can argue that that's a motive. Definitely that's a very common motive, right? You have Brian Albert, who's a good friend of Brian Higgins. They were together the entire day. Perhaps they were talking about his situation with Karen Reed. That could be in. He brought in Brian Albert to help him with that. And the hardest jump here is to Colin Albert. Colin Albert's going to be a little bit of a harder jump because just the fact that he put in the some beer cans in the bush, or he said "F you," that's going to be a harder connection there in Colin Albert. But in terms of Brian Albert and in terms of Brian Higgins, you definitely see that they had opportunity. They definitely had opportunity. And this is also kind of the argument that Brennan was making, that really there is no opportunity if nothing really puts them in the vicinity of the deceased. If they stayed in their house, and if the argument is that John O'Keefe never went into the house, well, then how did they ever have the opportunity to kill him? But again, we have the phone data showing that John O'Keefe's phone registered going up and downstairs. There's some evidence there that he was in the house. So, this is where this type of evidence is going to come in. So what I see happening, and it seems from all these cases, is that you definitely have to let the evidence come in. You have to see how this goes throughout the trial. And then after the close of the evidence, that's when Judge Cannoni can make a game time decision about whether she's going to allow, number one, a jury instruction to the jury about third-party culprit, and whether she's going to allow the defense to argue to the jury that this was a third-party culprit, as opposed to just attacking the police investigation. So it's a very different way that you set up your closing argument. If you're spending your closing argument trying to point your finger at another person, another culprit, then it's a different closing argument than just poking holes in the prosecution's case. So this is what was brought up today. I don't see, as Hank Brennan's argument winning so much here. Maybe as it relates to Colin Albert, I can hear that argument has the best chance of winning. But when it comes to Brian Albert and Brian Higgins, that's a little bit tougher to overcome. And these cases, like I said, are not exactly the same. And there are some other cases that David Iannetti cited. We're not going to go through all of his cases, but he also cited some cases which do allow you to show some evidence about this. So even if you're showing this evidence as just a Bowden defense, still the evidence should be able to come in. So again, the strongest argument here by the defense is that this should come in as a Bowden defense. All this evidence should come in one way or the other. And whether we can actually say the words to the jury that there's a third party who did this, instead, that's we can make a game time decision on that after the close of evidence. But all this evidence should still be allowed to come in, whether it relates to third party culprit or to Bowden. So we'll see what eventually Judge Cannoni does. I imagine that's how she's going to rule. I think that's what she ruled last trial. Allow the evidence to come in, see how the evidence comes in, and then afterwards decide whether they're, and she didn't allow them to open on it. So maybe she'll do the same thing in this case. But that is my take on the third party culprit stuff. So they went through the jury questionnaire. They poked around and changed some language in the jury questionnaire. There's of course some mentions about ARCA experts. Hank Brennan always wants to bring up the ARCA experts, that he's just flying blind and that he has no information, or definitely not enough information about the ARCA experts, and he continues to want ARCA more stuff. Apparently there's perhaps even a new expert witness that was listed by the defense last night that he mentioned that he wants to look over and maybe file a motion to strike that expert witness. Most likely he will, as we know from his pattern that he wants to get rid of all the defense's expert witnesses. So there's still a little bit more to do on this case. We're going to see some more leading up to the trial. Other than that, we have this trial coming up April 1st. And once jury selection begins, we'll see what happens, see how long it takes to pick a jury. So that's going to be it for now. I'm going to keep looking to see as soon as this opinion and order comes out about the motion to dismiss, which is going to be denied. I'm going to go through it, look at the analysis, look at the case law that she cites, and see whether I agree with it ultimately and show you why I agree or disagree. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.